Welcome back to Last Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Imagine the police are trying to search and arrest an individual in a private dwelling. They come up to the front door, but the occupant of the house refuses to let them in because they don't have a warrant. The question becomes to what extent the refusal to let the police in who lack a warrant can be used against that individual who is later charged with hindering or preventing an apprehension of a felon, which is essentially being an accessory after the fact. And before we answer that question, I want to thank you for watching me on YouTube, hitting the subscribe button, and sharing with my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we'll be discussing United States versus Sandra Prescott, and it deals with a warrantless entry into a home after Sandra refused to let the officers in, and of course the subsequent charges of being an accessory after the fact for her refusal. But first, let me give you some factual background so you understand what's going on. Federal agents were investigating a mail fraud scheme involving Mr. Duvarney, who was using stolen credit cards to obtain a merchandise and then have it shipped to him to his address. They knew that Mr. Duvarney was living at 546 Grove Avenue. It was a building with 4 apartments. At some point they obtained a search warrant for that particular apartment, but they never obtained an arrest warrant. After the investigation, they had some controlled mail that was sent to Mr. Duvarney, and at some point they made a decision to make the arrest. The officers had UPS deliver a package to Mr. Duvarney. He came outside and signed for the package. Then the officers, and by the way there were dozens of them, it was federal agents as well as local police. They had surveillance for the whole block. After Mr. Duvarney signed for the package, officers interviewed the UPS driver, made sure that the receipt was actually signed by Mr. Duvarney. They went to his apartment to execute an arrest. When they got to the apartment, they found out that there was a padlock on the outside. And it was obvious that Mr. Duvarney was not inside. How could he enter into his apartment and then padlock him from the outside? That just didn't make any sense. So then they began searching for him in other apartments. The other 2 apartments were vacant. There was nobody there. It was obvious that he wasn't there. So they went to Sandra Prescott's apartment, knocked on the door, identified themselves, and they were saying that they were looking for Mr. Duvarney. Now, Ms. Prescott said that she didn't know who this person was, that he didn't live at this apartment, they were new to the area, and didn't know their neighbors. She said that they were in their apartment with her husband and their daughter, and that's it. But the officers suspected that Mr. Duvarney was inside. They asked Ms. Prescott if they could enter the apartment. She did not allow them to do so. They left the apartment, walked around, tried searching for Mr. Duvarney in the area, couldn't find him, came back to Ms. Prescott's apartment again, talked to the husband, trying to get consent from him to enter. At some point, Ms. Prescott simply asked the officers if they had a warrant to enter. They say they didn't. And so again, she did not let them in. The officers then called the U.S. Attorney's Office for guidance. They then came back and told Ms. Prescott that she had 3 seconds to open the door, and if she refused, they would forcibly enter, which they did. Inside the apartment, They found, of course, Mr. Dovani, as well as some of the packages. He was arrested, but so was Ms. Prescott. She was arrested for being an accessory after the fact and for her refusal to let the officers enter the apartment. Now remember, the Fourth Amendment protects you against unreasonable searches and seizures, and generally speaking, officers need to have a warrant in order to conduct a search or seizure. Here, of course, we're talking about a seizure of a person, an arrest warrant. They didn't have one. So could the officers enter the apartment in order to execute an arrest of a felon? The Supreme Court has long held that police need no warrant to arrest a felony suspect on probable cause in a public place. But of course, in this case, we're not dealing with a public place. We're dealing with a private dwelling. In Coolidge, the court stated in dicta that the notion that the warrantless entry of a man's house in order to arrest him on probable cause is per se legitimate is in fundamental conflict with the basic principle of Fourth Amendment law, that searches and seizures inside a man's house without warrant are per se unreasonable in the absence of some one of the number of well-defined exigent circumstances. And of course, we have long held that every man's house is his castle. It is thus not surprising that the court has long recognized that physical entry of the home is the chief evil against which the wording of the Fourth Amendment is directed, and has traditionally afforded the most stringent Fourth Amendment protection to the sanctity of the private dwelling. In arriving to their conclusion, the Ninth Circuit gives a few examples. For example, if Mr. Dovani was arrested on the public street, obviously no warrant would be necessary then. The officers would then still need to get a warrant in order to go in Miss Prescott's apartment to retrieve the packages. Or another example, if the officers walked by Miss Prescott's apartment and through an open window in plain sight, which is an exception to the warrant requirement, would see the packages, they would still need to get a warrant in order to get inside the apartment and retrieve those packages. So the court says it doesn't make much sense that we would require a warrant for the officers to enter the apartment to retrieve the packages, but would not require a warrant in order to make an arrest. So at the end of the day, the Ninth Circuit rules that absent exigent circumstances, officers who have probable cause to arrest a felon must still need to get a warrant in order to execute that arrest in a private dwelling. Here, of course, Ms. Prescott argues that there were no exigent circumstances. Her apartment was only 5 blocks away from a federal courthouse, so she said they could have easily went and got the warrant. Of course, because of the non-violent nature of the crime, she says that it is unlikely that Mr. Dovani would have any sort of resistance or be violent with the agents or try to escape. Now, the court doesn't resolve it here because, again, we're in the appellate court, so instead they remand these questions back to the lower court in order for them to answer. But if there were no exigent circumstances, if the lower court would find that, all of the evidence that was found in the apartment, including the packages and the fact that Mr. Dovani was inside her apartment, would be suppressed and the jury would never be able to find it. So most likely, the charges would be dismissed against Ms. Prescott. The next question becomes whether her refusal to let the officers in can be used against her in the charge of being accessory after the fact. The court goes to explain that question simply because after remand, there could be another trial. And in that situation, in order to have the judicial economy and not to waste anyone's time, the Ninth Circuit decides to answer it. Here's why they decide to answer it. It is because the defense counsel for Ms. Prescott has already raised it in the lower court. Defense counsel sought repeatedly to argue to the jury that Prescott was not obligated to consent to the search of her apartment, and that her refusal to do so should not be considered as evidence against her. The court refused to permit this line of argument and refused to give a proposed jury instruction which stated in part, "It cannot be a crime, nor can it be evidence of a crime, for a citizen to refuse entry to his or her home to a law enforcement officer who does not have an appropriate warrant." The proposed instruction stated the law correctly, at least in this case, where there was no forcible resistance. It was prejudicial error to permit the government to prove, as evidence of the offense charged, that Prescott declined to unlock her door when the officers did not have a warrant. When a law enforcement officer claims authority to search a home under a warrant, he announces in effect that the occupant has no right to resist the search. When, on the other hand, the officer demands entry but presents no warrant, there is a presumption that the officer has no right to enter, because it is only in certain carefully defined circumstances that lack of a warrant is excused. An occupant can act on that presumption and refuse admission. He need not try to ascertain whether, in a particular case, the absence of a warrant is excused. He is not required to surrender his Fourth Amendment protection on the say-so of the officer. The amendment gives him a constitutional right to refuse to consent to entry and search. His asserting cannot be a crime, nor can it be evidence of a crime. The Supreme Court has long held that the privilege against self-incrimination under the Fifth Amendment cannot be used against the defendant. You can always refuse to answer the police questions, use your Fifth Amendment rights, and that cannot be used against you. The same line of reasoning applies to the Fourth Amendment. The courts will not penalize you for exercising your Fourth Amendment rights and refusing entry to your home, your constitutional right, in trial. Which means here, the court, if the case goes to trial, has to be very careful that the evidence that Ms. Prescott or anyone else refused entry into the home is not revealed to the jury. And if for some reason it is revealed, there should be a jury instruction saying that it is a constitutional right and the jury cannot hold it against Ms. Prescott for refusing officers to enter her home without a warrant. I hope you enjoyed this video. I hope you learned something more about the Fourth Amendment and the refusal to have the officers enter your home without a warrant cannot be used against you. If you like this video, please give it a thumbs up, subscribe to my channel, and share it with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.